Hi, Dr. Scott Jensen here. Filing lawsuits against the Minnesota Board of Medical Practice and the Minnesota Attorney General is not an easy task. To just give you a brief update of the history, from June of 2020 through January of 2023, I was investigated 6 times with nearly 20 complaints. A little more than a year ago, I had a conference meeting with the Minnesota Board of Medical Practice, and all the allegations were dismissed. No disciplinary action took place. The case was closed, and the Minnesota Board of Medical Practice made it very clear to me that our business was finished. But it was in the 6th investigation, coming in January of 2023, that I realized that I did not feel comfortable any longer going it alone without attorneys at my side. So in January of 2023, I hired Greg Joseph as my attorney, and along the way, James Dickey from the Upper Midwest Law Center joined our cause. They have both been outstanding. After all the charges by the Minnesota Board of Medical Practice were dismissed in March of 2023, over the next 60 to 90 days, I made the decision to file suit against the Board of Medical Practice for infringing on my First Amendment rights. Some of the initial steps in doing so required getting a chance to look at what kinds of emails and text messages and communications took place at the Minnesota Board of Medical Practice and at the Minnesota Attorney General's office and between the two entities. We have an act called the Minnesota Data Practices Act in Minnesota that allows public citizens to acquire data regarding themselves that might be going on behind the closed doors of government. So we requested all the documents and data that the Minnesota Board of Medical Practice and the Attorney General's office would have on me. We were planning on filing suit in May or June of 2023, depending upon what we could find through that freedom of information that we are entitled to. It was somewhat surprising for me to learn relatively quickly after our request for data regarding myself that the Attorney General's office distributed hundreds and hundreds of pages to us, all involving me, but also made it clear that they were not going to produce all of that which I might have expected, and that some documents and data points would be held back. And in part, this was because the Attorney General's office indicated that when I discussed these things publicly, I caused the Attorney General's staff to occasionally be harassed or called names by people contacting the Attorney General's office. This didn't sit right with me, nor did it sit right with my attorneys. So instead of filing a single lawsuit against the Minnesota Board of Medical Practice at a federal district court, now we were faced with filing a state district court lawsuit against the Attorney General's office for failure to abide by the Minnesota Data Practices Act. Both of those lawsuits were filed in June of 2023. I want to give you an update on the first lawsuit, the Minnesota District Court, where I am filing suit against the Attorney General's office. On March 28th, about a month ago, Judge Kane gave her opinion, and what she said was the following. She said that the defendants, which would be the Attorney General, that they had not produced all the documents that I have a right to see. Initially, there had been some 5,000 or 6,000 pages held back. But through negotiation between the Attorney General's office and my attorneys, that was able to be reduced dramatically to a point where the judge's office looked at some of the data being held back by the Attorney General to see if it was substantive or perhaps it should be excluded from me because it might represent attorney-client privilege. But nevertheless, when all the discussion and all the negotiation took place, there were still documents that had not been shared by the Attorney General's office with me. Judge Kane ruled the court will address data that the Office of the Attorney General is required to turn over to the plaintiff. And there were approximately 10 such data points. The judge said this in her ruling. She said, Scott Jensen is the subject of the data, and then followed it up with 11 document points. The second one, the judge's decision said, the emailer from the Office of the Attorney General provides a glib comment regarding the fame of the situation and dealing with the paparazzi. The Office of the Attorney General asserts withholding disclosure of this data on security information grounds. The judge said, no, you don't get to hold that back. On the number 3 data point the judge identified, the judge says, the emailer from the Office of the Attorney General again provides a glib response regarding the limelight of the situation. The judge said this document needed to be shared. You see, the Attorney General's office had basically said to me, we don't have to comply with the Minnesota Data Practices Act, and we're not going to. We'll give you what we want to give you or what we think you're entitled to. But there will be potentially hundreds or thousands of pages that you won't get. The judge said differently. The judge demanded that these documents be produced and shared with me. That was her ruling. Over the next few weeks, more discussions took place. And I'm glad to report that my attorneys and I have come to an agreement with the Attorney General's office and attorneys. And we have provided such agreement basis to the court. And on April 12th, 2004, the Second Judicial District Court in Minnesota recorded a stipulation for dismissal. And that basically means the case is over. And in it, for me, the crux of the matter was, number 2, defendants, that's the Attorney General's office, agree to produce items number 1 through 8 and 10 and 11. And they have done so. What did we learn? Well, I just shared a little information from the judge regarding this data that the Attorney General's office wanted to hold back. We learned that the Attorney General's office was aware of the fact that all it took for me to be investigated by the Minnesota Board of Medical Practice was a DFL hit piece or a tweet that was copied and pasted onto a Minnesota Board of Medical Practice webpage. We learned that there doesn't seem to be a lot of genuine fear on the part of the staff of the Attorney General. Rather, the tone was glib, according to the judge. And to my way of thinking, the tone was almost a mockery. So for the Attorney General's office to declare that they would not share all the data which I was entitled to because they were fearful that our having a discussion in the public square might cause the Attorney General's staff to come under criticism and harassment and potentially to be made to feel unsafe. That seems unfounded and without grounds. And the judge told the Attorney General's office, you will produce these results, these data points. And the Attorney General's office did. That case is closed. I did not ask the Attorney General's office to pay my legal fees, and I paid none of theirs. We simply took care of business, and we got that hammered out. That brings me now to the second lawsuit, which is still in process. Basically, that is a lawsuit against the Minnesota Board of Medical Practice for infringing on my First Amendment rights. We've been to court. The judge is the Honorable Jerry Blackwell. And in that case, I share the disappointing news that the attorney for the Minnesota Board of Medical Practice happens to be the Attorney General's office. So once again, the Minnesota Attorney General is involved in a lawsuit with me. But the attorneys representing the Minnesota Board of Medical Practice requested a dismissal of the case without us having a chance to go through the process. And we had our day in court, and I'm sad to say that the court ruled that the defendant's motion to dismiss would indeed be allowed. But the Honorable Judge Blackwell did say in the dismissal that it's dismissed without prejudice, meaning we have continued options, and that the plaintiff may file an amended complaint within 21 days from the date of the order. Well, we are indeed filing such an amended complaint and did so this afternoon. It's a long document, 70 plus pages. The crux of why my case against the Minnesota Board of Medical Practice was dismissed and will hopefully now be reconsidered by the judge is that he indicated I do not have legal standing to bring a case against the Minnesota Board of Medical Practice. Now, I'm not a lawyer, and if I use the wrong words, please forgive me. I'm trying my best. But I've done a lot of research, and according to numerous legal sources, the question, what is legal standing, can be answered as follows. In simple terms, courts use standing to ask this question: does this party have a dog in the fight? I thought I had a dog in the fight. Standing limits participation in lawsuits, meaning that you can't just bring a lawsuit against anybody and expect the court to move it on and have it processed. It might be dismissed outright if you don't have standing. Let's take for instance. Let's say that C fears D's dog might bite. C does not have standing to go to court and complain that he should be awarded damages because D's dog might bite him. C lacks standing because C has not actually been injured and cannot sue over his fear. That sort of gets at the concept of legal standing. Constitutional standards talk about fact, causation, and redressability. Constitutional requisites under Article 3 in the U.S. Constitution address the issue of standing by saying this: the plaintiff, which is me, must have 1, suffered actual or threatened injury. 2, that injury can be fairly traced to the challenge action of the defendant, which is the Minnesota Board of Medical Practice. And 3, that the injury that I suffered is likely to be redressed by a favorable decision, meaning that if I can get the court to rule that my First Amendment rights were violated, that will redress the situation, and it would. So, in simple terms, legal standing: does this party have a dog in the fight? The judge ruled that I did not have a dog in the fight, evidently. Heather Elliott wrote an article about standing issues, and she says this: the Supreme Court is often accused of using standing doctrine to manipulate its docket. Critics frequently see dismissals for lack of standing not as legitimate decisions about jurisdiction, but instead as the court's avoidance of a sensitive merits decision, or even as bias against a particular class of plaintiffs. I'll let those words stand for themselves, but those words were published in the William and Mary Bill of Rights Journal, titled, "Does the Supreme Court Ignore Standing Problems?" October 2014. Another article by Federalism and Separation of Powers Practice Group, June 25th, 2021. It says, why standing matters. And it says this: standing is the requirement that someone has suffered real and remediable harm as a result of someone else's conduct before they can bring a lawsuit. When we talk about standing, we're talking about two related things. One, the abstract requirement that a party must suffer harm before it can bring a lawsuit. And two, the case law about standing, which sets the rules the courts apply to determine whether someone has suffered harm. If someone's courthouse doors are closed to him or her, to have standing, a would-be plaintiff, me, has to show a concrete and particularized injury that is fairly traceable to the defendant's conduct. Particularized. So, Justice Elena Kagan on the U.S. Supreme Court said this about standing. Said, although standing is supposed to be an integral aspect of judicial restraint, the court transformed it into a tool of judicial aggrandizement or judicial expansion or enhancement of its authority, power, or ability to control the situation. Justice Elena Kagan was criticizing what the court has done with the law of standing. So right now, the lawsuit against the Minnesota Board of Medical Practice is under a decision by the court of dismissal. And we have amended our complaint and filed it today. I want to share one last thing. I think I have a dog in the fight. I think I have standing. And I want to tell you why. I think I was directly injured by the defendant, the Minnesota Board of Medical Practice, repeated investigations. I spent thousands of hours of my time that would have been available to communicate to voters while I was running for governor of Minnesota in 2022. The fifth investigation that I was under from the Minnesota Board of Medical Practice did not get closed within 1 year, as statute indicates it should. It went literally 15 months. I'm supposed to be kept appraised of the progress of an investigation against me at least every 120 days. I literally went a year without any indication from the Minnesota Board of Medical Practice where things were at. I was injured because I did decline numerous invitations to speak publicly about issues of the day, such as inflation, crime, education. What does informed consent and health freedom look like? The Board of Medical Practice investigations chilled my speech because I knew that I could lose my license. I was injured because the number of hours I had to spend dealing with Minnesota Board of Medical Practice issues numbered in the thousands, and I couldn't see patients during those hours. I resigned my position as a faculty member of the University of Minnesota Medical School following the first complaint because I did not want to have the University of Minnesota feeling obligated that they needed to come at me and investigate my actions as well. The American Board of Family Medicine investigated me based in part on the Minnesota Board of Medical Practice's investigation. Responding to the American Board of Family Medicine took hours and hours and hours and involved 100 pages of documents. There was no question that during my race for governor of 2022, I operated under the cloud of the fifth investigation, and my opponent used that gray cloud, that black cloud, to tweet as to what kind of a candidate could I be if I'm being investigated for the fifth time by the Board of Medical Practice. I was the family physician of the year in Minnesota in 2016, and yet in 2020, I was accused over and over again of disseminating misinformation and disinformation. And when I had my conference with the Minnesota Board of Medical Practice, prior to all of the allegations being dismissed, I asked the question of the board, how do you distinguish between misinformation and disinformation? And they were at a loss to make such a distinction. And yet these terms are cast about casually as if I'm guilty of either. And I was not. I think I've been injured. I think I have a dog in the fight. I think my First Amendment rights were violated. I think that the Minnesota Board of Medical Practice could have done things differently. There was one complaint that came against me that they dismissed outright. They never contacted me until after the complaint had been dismissed, and they said, we dismissed it. They could have and should have done that with repeated allegations against me, but they did not. And the fifth investigation went on for more than 15 months and took place during the entire 2022 campaign. A decision by the court to advise the Minnesota Board of Medical Practice that their procedures and operations and practices violated my First Amendment rights would redress the situation. That's why we filed an amended complaint today. It's available on the public record. You'll be able to access it by going to my website, drscottjensen.com, DRSCOTTJENSEN.com. The bottom line is my state district suit against the Attorney General in Minnesota has been settled, and they have produced documents that I was entitled to that they initially resisted. My ongoing case against the Minnesota Board of Medical Practice in the federal court is ongoing, and now I've submitted an amended complaint. I think I have standing. I was disappointed and more than a little surprised to learn that the court dismissed my complaint, saying I didn't have a dog in the fight. I'll keep you posted. Thank you.